Now, in the course of news gathering, we can somehow cross boundaries. We've talked about privacy a little bit, but now we need to really look at that and going beyond in terms of news gathering, and whether we're doing our job, whether we're being annoying, or whether we're actually crossing a legal line. Now, harassment is crossing a line that goes beyond news gathering. I've mentioned to you under privacy Ron Galella. Ron is pictured here. He was actually sued by Jackie Kennedy because he was taking pictures of her everywhere she went. He was always in her face with a camera. He ended up getting a restraining order against him. So there is such a thing as tortious news gathering, which basically establishes a liability for trespassing in the course of doing news gathering. One of the cases that we can look at here is the Wolfson versus Lewis case, where we had a couple of reporters for Inside Edition, and they were investigating the private lives of U.S. healthcare executives. They started gathering video footage of this couple, the Wolfsons. They followed them around in a van with tinted windows. They did ambush interviews. They used shotgun mics, telephoto lenses. The Wolfsons ended up suing under this common law tort of intrusion upon seclusion, and a judge did prohibit the Inside Edition reporters from engaging in any further conduct that would invade the privacy of the Wolfsons. So this balance of the First Amendment against this invasion of privacy in this case fell on the side of invasion of privacy. The idea of fraud and misrepresentation, by either presenting false evidence or concealing what should have been disclosed, that's also an issue where we sometimes straddle a journalistic line, and journalists can be held liable when they try to obtain information using a lie. So one of the most famous cases related to this is the Food Lion versus Capital Cities. Capital Cities is ABC. Primetime Live was airing a program about food handling practices. They ended up getting these reporters to go in undercover and record. Now, Food Lion sues, saying that it was unfair because they got access by getting jobs with Food Lion, and they came in and recorded them. The court decided that the producers actually had trespassed. They had permission to be in the store, but they didn't have the permission to videotape the footage in these areas that were not public. Now, an appeals court ended up overturning this because Food Lion actually failed to show that it had suffered any injury. But the idea being that we need to really pay attention when we go undercover as to whether or not this is going to be legal. Now, disaster scenes, it's important to note that the First Amendment does not give us any special rights or opportunities to go where the public is not welcome. There are states, 3 specifically, California, Ohio, and Oregon, have extra protection, so there are opportunities for press to get greater access. But basically, if you fail to obey police at a scene, similarly to any person who happens to be there, any individual, you actually could be violating laws. Covert recording is an area where journalists can fairly easily get into some trouble, so it's important to know the law. We have 38 states and the District of Columbia that have what's called one-party consent, and that means only one person in a conversation needs to know they're being recorded. So if I'm doing an interview with you, I'm recording it, I know it, you don't know we're being recorded, that's legal in those states. It is illegal in 12 states, which have what's called all-party consent. I've listed them for you here. So in that case, before you start recording, you need to say, I'd like to record you, can I have your permission? And then the person either does or does not give your permission. Now, there's often a question if it's the originating state or the destination state whose law you follow. I would always fall on the side of caution. So if I'm calling someone in California, I'm certainly going to make sure that I'm going to ask whether or not to record them. And truthfully, good journalistic practice from an integrity standpoint is to always ask before you record people. There was a case that helps us identify what to do here. Tierney versus Solomon Smith Barney in 2006. In this case, the plaintiff, Tierney, said that Solomon Smith Barney recorded conversations between its employees in Georgia and plaintiffs in California without consent. Now, a Superior Court in San Francisco dismisses the complaint, saying that the calls were subject to and lawful under Georgia's one-party state, and it was upheld by the California Court of Appeals. But the Supreme Court said that the Invasion of Privacy Act applies even when one party of the conversation is outside of California. So this legal case says specifically that if you're recording someone in the state of California, California law applies. Of course, if you don't tell anyone that they're being recorded, that can violate the Wiretap Act. So it's important that you be very careful around this one. And then remember the Bartnicki versus Hopper case as it relates to obtaining, as a news source, obtaining information that's been recorded that may violate this, just so we can remember exactly what the court has outlined for us. Now, recording in public is something that we do quite often. We are legally protected from recording audio that takes place in public, shooting photos of things that take place in public. Things that you can easily see or hear in the public space is certainly open for chronicling. Now, often as a reporter, I certainly had police tell me that I'm not allowed to be taking photos, I'm not allowed to be recording things. This has been a big issue, certainly as it relates to recent issues of police versus individuals. But what is important to note is this case, Glick versus Cunha from 2011, actually outlines specifically what your rights are. Simon Glick was filming with his cell phone, Boston officers making an arrest. He felt that it could be police brutality. He was actually charged with wiretapping because he was recording people and he was not a party to the conversation. Now, the court had recognized that videotaping of public officials was an exercise of First Amendment liberty, and this isn't just limited to reporters. This is limited to anyone who's out there. So it actually found that Glick had a constitutional right to videotape a public official in a public space.